Good afternoon. My name is Kate Shank. I'm the Deputy Director of Legal Aid Chicago, and welcome to our final installment of our series, Legal Aid Matters. Today, we're going to discuss the eviction court procedures and updates in Cook County. In order to get us started, I'd like to welcome, to thank, and to turn it over to Denerica Brooks and Michelle Gilbert.
Good afternoon. I'm Denerica Brooks. I am the director of the Housing Practice Group here at Legal Aid Chicago, and I am so delighted to be doing this webinar together with Michelle Gilbert.
And hi, I'm Michelle Gilbert, and I'm Legal and Policy Director at Lawyers Committee for Better Housing. And if you think, oh, that name sounds sort of familiar, I was one of the initial supervising attorneys in the Housing Practice Group, and I have been here at Lawyers Committee for 2 years. I'm very excited to be working on this webinar and on all of these developments that we've been seeing in eviction court.
So, what are we going to do today? We are excited to share with you today a lot of the different updates and changes that have happened in eviction courts and in eviction practices over the last couple of years. So we're going to start with just a general overview. Why are we still discussing evictions? What happened to the anticipated COVID tsunami that everyone talked about and heard about throughout the media for the last couple of years? What interventions have been put in place since COVID-19 pandemic, like the Cook County Legal Aid for Housing and Assistance Debt? And we are going to finish up with an exciting new development, which is the right to counsel.
So why are we still discussing evictions? I will say that in the Housing Practice Group and over here in Lawyers Committee, we've been discussing evictions for a long time. There was a point during the pandemic that I felt like people like me have been kind of out in the desert talking about evictions and how terrible evictions are for families for a long time. And I felt like, wow, what we're saying is finally catching on. Eviction is affecting a lot of people, or threatening to affect a lot of people whom it had not previously affected. And why have we been discussing eviction? Because eviction is so devastating for families. So imagine for a moment the last time you moved. You know, you looked at different neighborhoods. If your kids were still in school, you looked at different schools. You timed that move to make sure that your children could move at the right time for them educationally. And now imagine a tenant who has gotten an eviction notice and about to go to eviction court, and they're going to have to make that move decision in a few weeks. Their children are going to have to leave school if they end up somewhere not near to their school. They're going to have to find a place for their possessions. And a lot of times people they just need to move out before the sheriff gets there. And they either leave possessions behind or they put them in storage that they can't later afford, and they've got to start over again. Evictions also impact the entire community, because when there's an eviction, the landlord and the community loses the money that would have gone in for the rent. And so I'm going to pick that string back up when we talk about rental assistance. But like everything else that's bad that happens in society, evictions definitely have a disproportionate impact on race. So I'm going to hand it over to Denerica to talk about some statistics about that.
So let's talk a little bit about racial justice and why it matters. One of the underlying currents of eviction law is that evictions disproportionately impact Black people, but Black women specifically. So Black women are overwhelmingly evicted in the United States. This is across the nation. It happens in every state. Specifically, it also happens really bad in Cook County and the city of Chicago. There was a study done by the ACLU that really found that in a period of time between 2012 and 2016, 17 out of 36 states, Black women had evictions filed against them at a rate of at least twice that of whites. And so one of the other things that we know is of the people that are disproportionately affected by eviction, it's single moms, moms with children who then have their entire lives disrupted, and we all know that there are societal harms that are caused behind that, including disruption of education. Like, one of the things, or a way to think about it, is practically speaking, if a child is in eviction court, or their family is in eviction court to be more specific, and that child is going to be evicted, a kid is in school and they're wondering, what am I going to do after school? Where are we sleeping tonight? Are we sleeping across town? Are we couch surfing in the suburbs? And that also leads to other things: lack of focus, tardiness in school. If you're miles and miles away from your designated school and you're couch surfing, sometimes you could be late to getting to school. So there's a whole societal impact that is associated with evictions. And those impacts are being found in Chicago on the South Side and South suburbs, and on the West Side and West suburbs, and predominantly Black and Brown communities. In 2019, the census found that, just looking at it practically, to put, a name on it. So whites make up 41.8% of residents in Cook County. Blacks make up 22.7%. And despite those makeups and demographics, when we actually look at who is actually being evicted, there are eviction filings at 59% for Black folks and 23% of whites. So that means that evictions are disproportionately filed against people of color. Not to say that Blacks are just always defaulting, but frankly speaking, they just don't get as many opportunities to cure problems. They get a little less leeway when it comes to disputes and even interpersonal conflicts with property management companies and landlords. One of the things that we have to think about is, where does implicit bias show up? When we have tenants and we see tenants who may get into an argument over repairs, or they go demanding repairs be made in their homes, and then that all familiar trope of being an angry Black woman or an angry Black man comes up, and now you're a threat. You're threatening to your landlord or your property manager. And we see a lot of things like that in Cook County, even violent temper tantrums, just for interpersonal conflict. So that's one thing to consider about the ways that evictions are being administered, implemented, and filed in Cook County.
So if you're interested at all in eviction, you may have heard of the book Evicted by Matthew Desmond that came out several years ago. And one of the things that he really realized is that even though evictions have this impact on families and communities and societies generally, there was actually very little research about who was being evicted and where. And that really came as a challenge to Lawyers Committee. And I can talk about how great this is immodestly because I wasn't here yet. But having done some research on post-foreclosure evictions, Lawyers Committee has over time gotten a decade of data of Chicago only, so not Cook County, Chicago only evictions, and looked at a lot of different data points, some of which I'll discuss later. If you're interested in topics like this, I encourage you to click over to the LCBH eviction data portal. But it was clear, Zaneric and I knew, to God, we knew that evictions disproportionately affected Black women because we had walked around the 14th floor. We saw who was there. But some people need stories and some people need data. And that was a data point that the Lawyers Committee collected. You can see in this graph, the teal areas are those community areas in Chicago that are African-American communities. And that's clearly where the eviction filings are the most. And without getting too data-driven, I can say that the data portal also supports statistically exactly what Danica was just talking about, that landlords are quicker and more likely to file evictions in largely African-American communities. even when you then look at the result, and the results aren't as dramatic as the filings. Landlords are just more likely and more quick to file evictions in Chicago's Black communities.
And where does that lead us? That leads us to the disparate impact of eviction records. Specifically, the eviction court process is supposed to be neutral on its face. It's supposed to apply to everyone, but the way that it is being used and implemented creates a disparate impact, meaning that because filings are made predominantly against Black and Brown people, that there will have or will be larger societal effects to those communities of color. So one of the things that happens is that when an eviction case is filed, that's when we see problems where people are then being barred from housing because they have an eviction record, they have an eviction filing. No one cares about what happens after that. And there's this stigma that then traps people on some of the more impoverished neighborhoods on the South and West Side, or those that have to go to subpar housing because those are the landlords that will rent to them. So because of the eviction filing itself, tenants can be excluded from new housing or from housing in opportunity areas, which are those areas with access to hospitals, to food, to jobs and better transportation. And then we have these companies that will screen out tenants. The problem is that there isn't much follow-up. So once an eviction is filed, screening companies will be present. They will look and they will get a list of the filing of the eviction action and then do nothing with it. There's no follow-up. They don't follow up to see if the tenant won. They don't follow up to see if the case was dismissed. They don't follow up to see if the tenant was actually evicted or if there was a settlement. And frankly, looking at these policies, they are very confusing. An eviction filing for a lease not being renewed looks exactly the same as an eviction filing for someone that is being evicted for murdering someone in the unit. They look exactly the same on paper, but landlords will only look at that. And so there's this false attribution theory that because an eviction is filed against you, you must have done something wrong. And then that really does serve to perpetuate segregation because again, you can't move into a building in River North with an eviction on your record. You're usually screened right out from the beginning. And that perpetuates segregation. And then that just continues to just create this stigma associated with eviction where people are trapped where they are, or even just saying, who will take me? Who will accept me with this eviction on my record? Who will not take my application fee and run? And so it's just a cycle that continues and continues. I had a client that had an eviction on her record from 8 years ago, where she actually won her eviction case and she still cannot find housing because the eviction is on her record.
Before going forward, I'm just going to reiterate that point. When I was at Legal Aid Chicago, I represented this client, had this great case. We ended up, the case against her was dismissed. She got $6,000 in payment. Her landlord had been doing an illegal utility tap. And because the case had gone on for a long time, even though the file was ultimately sealed, the fact of the filing still was held against her. You know, a couple of years later, she would call me and say, well, she needed some record from her file to show that she had actually won her case. What more do we know about eviction court? This statistic from the eviction data portal kind of tells you a lot about why these things happened in eviction court. Landlords are represented by attorneys in about 80% of the cases, and tenants are represented by the attorney. And the numbers really vary, but the number that that we found was about 12% of the time. And you know, it almost goes without saying, well, attorneys must be very helpful in eviction court, or so many landlords wouldn't have hired them. And so this is this is a very blatant statistic that it's our goal to do something about. So not only do we know that attorneys help clients just as a matter of common sense, right? We're attorneys, we help our clients, but the LCBH's eviction study found that the outcomes were better if the tenant had an attorney, and the outcomes were significantly better if the tenant had a legal aid type attorney. And so that's why it became our goal to get more attorneys for tenants in eviction court. So what happened in eviction court prior to the pandemic? Tenants would receive the summons with as few as 7 days before court. I mean, we, the housing practice group, would prep that intake specialists. Like, this is how you tell a client to go to court. They have to just keep saying over and over again, I need a continuance, I need a continuance. Don't say anything about the case. Like, if the tenant would begin to say, oh, but I didn't get a notice, or I have this issue, then the judge would move right into having a trial and they wouldn't get their continuance, because that first court date was set at a trial. Even sometimes when they were well coached, the judges still wouldn't grant a continuance. If they didn't have an attorney, they might be denied opportunities to present defenses. I mean, sitting in court waiting for cases to be called, I heard so often judges say, if a tenant tried to show them photos or whatever about conditions problems, they would say, oh, well, that's for building court, that's not for eviction court, even though Illinois has had on the books an Illinois Supreme Court case since the 1970s that say conditions are defenses. Many of the cases would result in judgment on that very first court date, including a lot of default judgments, which is also something else that we hope to address. And there would be very few resources available in eviction court. These are all issues that our offices together, along with other legal aid providers, kind of the larger community, say like the Appleseed Fund, Chicago Council for Lawyers, the other bar associations would be working on, either through meetings with court officials, engaging in policy advocacy, and undertaking appeals. So all of these things we already had on our radar, we were trying to work on, and then the pandemic hit, and things were about to change.
Speaking of change, I realized that most people probably don't know who Sam Cooke is if we have a younger demographic, but a change is on the horizon. A change has come, and we hope that change will continue to come. I know that we started off this webinar with a little bit of a heavy feel, because eviction court is heavy. It is hard and it's painful for families, and it really is something that just affects entire communities. But some of the things that we knew that could improve the administration of eviction courts are now actually happening. If we could go to the next slide. So, and I don't hate to say this, I'll just say it for what it is. But all the things that we talked about and had worked on and talked about how eviction court could change, we all knew it. And we had all been voicing opinions and solutions to those changes to give people an actual access to justice in eviction courts, and to give them a chance to avail themselves of the rights that they have. But it wasn't until the pandemic hit that that opportunity actually arose. And that opportunity arose because all of a sudden, it wasn't just Black and brown folks that were at risk of eviction. It was everybody. It was white people. It was the middle class. And now it became important to actually do something about the way that eviction courts operate. So in that, the legal community, the legal aid community really came together in the summer of 2020, spring, summer 2020, and started looking at possible solutions about what can we do to try to keep people stably housed, to keep the COVID-19 virus from spreading, to keep deaths down, to just keep people in a safe environment where they could shelter in place. What could we do at a local level to try to resolve conflict? And not just for the tenants, but for the landlords as well, whose mortgages depended on rent, who needed to have stability of their own. But what could we do as a community to come together as a community for the city and for this county? And one of the things that came out of that is the Cook County Legal Aid for Housing and Debt program called CCLAD. It really is a collaboration between the Chicago Bar Foundation, Legal Aid Chicago, Lawyers Committee for Better Housing, CARPLS, the Center for Conflict Resolution, several other legal aid agencies that got together, are at the table and providing legal services, mediation, rental assistance to those that are in need. It's a county-wide initiative, and the eviction portion, we call it the early resolution program. But the idea is to try to find creative ways to resolve housing disputes, landlord-tenant disputes, and eviction matters. So under the early resolution project, the courts are actually involved in this too, through administrative orders that really govern the way that the courts operate. Under the ERP program, the court requires that at least 30 days from filing to the first court date. So pre-pandemic, you could have gotten your summons and go to court within 7 days. Within the ERP project, you get your summons and you have 30 days before you appear in court. The first court date is no longer set as a trial. It is set as an initial case management date. That means that you go in, and on the first court date, you might get a 14-day continuance, but it's institutionalized. You don't have to argue and fight for that 14-day continuance anymore. It's just given as a right. And then if you go in on the first court date, what happens is, your case is actually sent to case managers who refer you to rental assistance. They connect you with other legal aid organizations. You can apply for court-based rental assistance, engage in mediation, which is a process where you and your landlord get together with a neutral third party and see if there's any way that you can come up with a resolution or resolve your differences. And then you continue the case to a future court date to allow the process to follow through. And Michelle, I'm going to pass it over to you.
So the early resolution program has been great because it's not just about putting those resources, the legal aid, the rental assistance, but it has also brought out all these structural changes that Denerica just spoke about, things that we had been hoping for a long time. And those have been reasons, having access to the resources and to the structural changes, that has helped prevent that tsunami of evictions that everyone was worried about, that we were very much worried about. But the other big change is that there had been some sporadic rental assistance programs that were available pre-pandemic. But there was an enormous movement of money. And I'm not going to go through, you can read the slides and you can get them. And these don't even cover all of the money. This slide, so this is for the state of Illinois, and then the next for the city of Chicago and for Cook County, which got separate streams of funding. And this isn't even the summary because there's still money that's being distributed. And it's already over $1 billion. And clearly without that money, those tenants, landlords and tenants, and it's rental assistance, it benefits tenants, but nearly all of the checks go straight to the landlord. I mean, that money not only helped those tenants stay housed, it helped stabilize the communities where the landlords receive them. It prevented people from being evicted, and it also often prevents them from having a huge judgment against them, which would impact them long-term. One of the things that happened, again, something that we had been working on, a bill that I really never thought I'd see pass, was the Chicago City Council first in July 2020, and then the Cook County Board in January 20, effective January 2020. Oh, no, I'm sorry, past 2021, effective June 2021, passed what we all call pay to stay bills. So in the past, a tenant could get a 5-day notice, and if they couldn't pay within the 5 days, then the landlord could bring the eviction case. These two local enactments allow Cook County tenants to pay the amount that is owed plus the filing fee, and allows them to stay in the premises. So working with rental assistance and with pay to stay, our organizations have been pretty successful in keeping tenants in their homes. You know, it's funny, in my job, I go from like a real macro level where I'm meeting with people from IDA, and then, you know, in the afternoon, I might be, IDA, Illinois Housing Development Authority, which administered a lot of the rental assistance money for the state of Illinois. And then I'm working on an individual case. And, you know, if anyone's going to ask a question, oh, has rental assistance worked perfectly? You know, you try to give away $1 billion in 2 years, there's going to be problems. So on a micro level, I know that there have been problems, but in a macro level, we know that it has prevented evictions because we can look at where the eviction filings are now. So pass it back to Danica.
And so current eviction trends, we talked a little bit about the tsunami that everyone expected and everyone expected. And as Michelle said, the rental assistance, the ERP program have really been influential in making sure that these cases have been resolved. But eviction cases are back. I think this chart is pretty self-explanatory. So in 2019, per month, there were more than 2,000 cases that were filed in 2019 per month. And in 2020, once the world shut down in March, those numbers started going down, because one of the misconceptions that people have is that because there was a moratorium in place, a federal moratorium, that, oh, no one was being evicted. And I just want to be clear that evictions continued to be filed throughout the pandemic. But they were filed at very much reduced numbers. But as we can also see, starting in 2020 with the expiration of the different moratoria, both federal and state, in 2021, those numbers started to tick back up. We are now back at pre-pandemic filing levels for evictions. And although we are back at pre-pandemic levels, we know that ERP, or the Early Resolution Program, is successful because the sheriff isn't executing nearly as many evictions as they were in 2019. So evictions are being called off, cases are being settled, but the sheriff is not having to evict people or execute evictions at the rate that they were pre-pandemic.
One other thing that got attention during the pandemic is what we had been talking about, eviction records, and how they make it more difficult for tenants to find housing. There are actually 2 great articles. It was easy for me to pull up this Consumer Report site. It actually talks about a tenant that Lawyers Committee helped, who continued to experience the difficulty finding housing after she had an eviction filed. There's also a really great New York Times article that talks about a Legal Aid Chicago client who experienced continuing difficulty finding housing after her records were sealed, or after her eviction was filed. So the idea of sealing these eviction records during the pandemic got a lot of attention. And as part of a bill that affected a lot of COVID-related emergency rental assistance and record sealing, the General Assembly and the governor signed into law legislation that did two things with record sealing. One, all of the eviction records, the residential eviction records that were filed during the COVID period, so March 2020 to March 22, were presumptively sealed. So when they were filed, they were not accessible as public records, and then a judge could open them later if the tenant lost. Although I have found a lot of those have not been reopened, which works out well, even when the tenant is lost. So those records, are not accessible. Just a recognition that people who are going to have eviction filings during the COVID period probably had some pretty good excuse for that happening. The second piece was to change the standard for sealing old eviction records. So anything pre-pandemic, there is an eviction sealing law. It's a really high standard, really hard to get. You could actually win a case and still not get the file sealed. Sometimes you could do it by agreement, but there would even be judges who would say, I don't care if it's by agreement, you still have to meet this really high standard. So this legislation reduced the standard, and unfortunately, it's only in place up until the end of July. So we're actually kind of going crazy filing sealing motions. We've been having clinics. It's a little bit like the expungement of criminal records. You may have heard about like expunging the cannabis records. We're kind of doing it on the civil side, and we've been having clinics out in communities, working with community partners, law schools, a lot of law firm volunteers. We have 2 more sealing clinics because we only have until the end of July, but I guarantee you there'll be another legislative session in January 2023, and we will be back there trying to get this law in place permanently.
So right now, if you are seeking CLE credit, the code for CLE credit is PQL932. That's PQL932. And just a reminder that the form is in the chat for you to record your CLE credit if you are seeking it.
So what's next? Our Right to Counsel pilot project. Janerika is going to talk a minute about where Right to Counsel is in other states. Make sure to other states and cities, make sure to recognize that that's not where we are in Chicago yet, but we've started this pilot project. I'll let you go to the next slide to talk about the Right to Counsel benefits.
So why is a Right to Counsel? I think that a lot of people have heard about it. There's actually a national movement right now that is trying to get a right to counsel in eviction cases, specifically because of the recognition that the effect that evictions have on individuals, on families, on communities. So it's a cyclical disparate impact or negative impact, where if you have an eviction on your record, you may lose your job. If you are going through the eviction process, you may lose your job. If you're couch searching, you're still trying to get to work on time. You're still trying to get to school on time. And all of those things really are disruptive. But it also decreases housing choice, which we spoke a little bit about earlier with that eviction filing on your record, not being able to rent where you want to, even if you can afford it. Child education disruptions, having to move schools or increase in tardiness or not getting homework done, just very practical things associated with being unstably housed. And then community destabilization. When evictions happen, there's disinvestment in the communities. If you have small mom and pop landlords, they may have troubles paying their mortgage or keeping their properties, which in Black and Brown communities can lead to that lack of creating generational wealth or an inability to create generational wealth. Desperation. People in desperate situations do desperate things, which then lead to increase in crime. And at least one study says that there's an increase in the rate of homicide where evictions are very high. And I would posture that in Chicago, we see some of those same effects. And so we know what happens practically to the communities that are decimated and devastated by eviction. And right to counsel is one of the things that could serve as a solution. Stabilize credit to increase housing choice. It allows people to, if they are not evicted or become homeless, they can maintain their employment because they now have stable housing. Increased in housing mobility, where you now have opportunities to move into the neighborhoods or the areas that you want. Increased educational stability, community stabilization, where you may have community investment. You can actually move away from food apartheid, essentially, a decrease in crime and community investment. So there's really a very positive impact on the communities, but also the municipalities and states that have right to counsel. Studies have shown that when a right to counsel has been implemented, those dollars saved come in not having to provide as much support to homeless shelters or emergency rooms where people stay because they don't have anywhere to go, or other social supportive services. Those costs go down because people have an opportunity to avail themselves of their rights in housing, to resolve conflict, and to maintain stable housing. So, like I said, this is a movement. There's a coalition. There are municipalities across the country that have implemented some form of the other of right to counsel. So of New York, San Francisco, I mean, you can really go down the line and see. I will say that this list is not exhaustive. During the COVID pandemic in 2021 and 2022, a lot more municipalities looked into having some form of a right to counsel. They are a little bit different depending on where you go. Some require income limits. Some require that there be a child in the household or other vulnerable population. So there's just different ways to craft it. And then these municipalities and even states are those that have actually provided funds from the state to actually provide a right to counsel in eviction actions. So it's something that's happening across the board, slowly but surely, and very much picking up over the last couple of years. And that leads us to what we're doing now here in Chicago.
So the Chicago Right to Counsel pilot project is going to fit like a Lego block onto the early resolution program. That will continue to be the, I don't want to say intake device, but that will be the inflow device. We will still provide ERP services with the goal that a lot of cases will get resolved. I mean, I've done like a lot of areas of law, and, you know, court cases often get settled from the biggest case to the smallest case. And that is true in evictions as well. But some cases don't get settled, or tenants are offered really, insufficient settlements. So we will be able to move the case. Either we'll be able to keep it, one of us will be able to keep it internally, or we'll move from the other ERP partners and be able to provide extended representation. And that means that we will file appearances or appearances and jury demands. We will take the case, a lot of motion practice in eviction court, lots of procedural defenses. It will be filing motions to dismiss. And when we need to, we'll take cases to trial. Our goal is not just to win those cases, which of course is an important goal in every case that you sign the retainer on the dotted line, but to make it clear to landlords and landlords' attorneys that that option is there. Like, well, you may not like this settlement, but do you really want Generica to be filing motions and propounding discovery? Because that's what you're going to get if you don't work out this settlement. I mean, these are things that we know how to do very well. It's a new project, but we're not recreating, the work that, we're not recreating a new thing. We're doing the work that we've done all along. We're expanding that service. Among other goals, it is a personal goal of mine to get that default rate down, to let people know that eviction court is a place, it's not Candyland, but it's not a place to be afraid of because there are services there. We will continue to have, as long as federally funded emergency rental assistance has not been spent out, we will continue to have that, and we'll be, there's some state funding, there are other ways that we'll have rental assistance, and then we'll continue to be the sort of supportive services and the mediation that we're providing in ERP. So, definitely encouraging people to go to eviction court. That's the kind of my motto. Don't self-evict, go to eviction court. That's where the services are. And the county is committed to keeping eviction court, certainly that initial level. We don't know what's going to happen, for the whole next 3 years, but that initial ERP is going to stay in Zoom for a while. And in a way, it's tough for tenants if you don't go to Zoom all the time, but it also, there are lots of ways that are easier. You don't have to take off the whole day of work. You can you can sit in your Zoom, and you don't have to find a sitter for your kids. So our good friend Bob Glaves from CBA, as we were creating the ERP, and I'm sorry I keep using that initial, but it's a lot of syllables. So ERP is an initial you got to catch on to. So Bob would say, we're flying the airplane while we're still building it with ERP, because we would do something, we say, oh, well, we hadn't thought of that. Like, well, let's do this instead. I'd say we're a little bit ahead of that with right to counsel because it is work that we've been doing, but there are a lot of questions. We're happy to answer new questions, but there are probably some questions that Generic and I don't know the answer to yet. We will be working primarily these 3 organizations, but we will be able to take referrals from the other ERP partners like Chicago Volunteer Legal Services, Center for Elder and Disability Law. We'll have our traditional intake as well, because there are some clients who are always going to call, who was their attorney in the last case. The Chicago Bar Foundation is sort of an unfunded coordinator. The Bar Foundation has really been amazing dealing with the courts and dealing with the government and providing a lot of overall coordination. And then just like ERP has an evaluation component written in, so each intake includes a series of questions about the tenant's court experience. And then when we close the file, there are other questions that we need to ask. And that's being conducted by Stout, which is a private consulting firm that has done a lot of work on right to counsel and return on investment for right to counsel and cost benefit analysis. So Stout is evaluating ERP and also is part of the right to counsel evaluation. Again, just building off of what we're already doing. So for next steps with ERP, we will, ERP will be open July 1.
Right to counsel.
Oh yeah, ERP. Sorry, thank you. I don't know. I was like, I've said ERP several times an hour for the last 2 years. I can't get it out of my head. So right to counsel will be open on July 1, but we're considering it sort of like a restaurant, that does that soft opening with just, friends and neighbors. you know, we have, like I said, we have attorneys who'll be doing this, have been doing the work, and we'll you know, it will be under the banner of Right to Counsel. Both of our organizations have hired 2022 grads or other, you know, new attorneys, perhaps leaving fellowships that we're going to get in September. So July and August are going to be places where we're going to figure out some things, and then September will be opening up a little bit more once we get those new attorneys trained up. We're going to try to do things that we have learned from having to operate in the pandemic, you know, doing things by Zoom, automating. I mean, one thing that we've learned in the ceiling clinic, the head of our reintervention project created a ceiling app. I'm not a big computer person, but any unrepresented tenant can create a ceiling motion easier than ordering Thai food. You know, you just have to answer a few questions, and I love it. Immediately the motion appears, you know, in the order, in the and I'm like, why aren't we doing this with motions to vacate default judgments? So we're going to be doing a lot of training, you know, co-training with our supervisors. If anyone from Consumer Practice Group is listening in, my guys need some bankruptcy training, and I have been too far away from bankruptcy. That is high on our agenda. And again, Right to Counsel is just a pilot project in Chicago. You know, we need to be on that list. I mean, Cleveland is on the list, you know, New Orleans, cities that are smaller, have fewer resources than Chicago. We need to be on the full Right to Counsel list. And that's going to happen with an appropriation from City Council and some legislation. And that's obviously our goal, to get an ordinance passed that establishes a Right to Counsel. And, you know, that's why we're doing the evaluation, because we want to really show that there is a cost benefit analysis, just like has been shown in other cities.
So with that, we really hope that this has been helpful information. We are trying to change the landscape, change the culture of eviction court in the way that it operates on all sides. And especially with ERP, or the Early Resolution Program, it is our sincerest hope that what we are doing here can be a model for other jurisdictions across the country to try to look at evictions differently, to help everybody involved and to help the communities involved, and as a tool to desegregate.
Thank you so much, Janerica and Michelle. What an outstanding presentation, so incredibly informative and interesting. What I'd like to do next is to share a number of ways that you as viewers and participants in this webinar can get engaged with our organization. So we definitely appreciate any financial contributions that you're able to make, because our work depends on private support. If you're a young professional, you're encouraged to join our ambassadors board to help fundraise and to spread the word about Legal Aid Chicago. We also have volunteer opportunities. We, of course, have them for attorneys, but we also have opportunities where a law license is not required. So you can learn more about those opportunities on our website. So this is the end of the planned content portion of today's presentation. But what we're going to do is we're going to start the Q&A portion next. Before that, though, quick reminder, use the link in the chat to obtain CLE credit and to give course evaluation. And again, thank you so much for taking part in this, our third year of our webinar series. So our panelists are going to stay on to answer questions, which again, you are very welcome to type into the Q&A at the bottom of the screen. And we already have some great questions that have come in. So I'm just going to launch right into those. Let's see. One that is kind of speaking to the issues of eviction records. What are some things that someone who has an eviction record can do to get a landlord to rent to them? You know, aside from putting down a significantly increased security deposit or paying a lot of rent up front. Are there any other tools that tenants can employ?
Well, there are a couple of things I would say. One of which is if there is a record of that eviction that shows that, it was for just a lease terminating as opposed to like a default in rent, or something to show that it was de minimis, I would try to get a copy of those records. How did the case end itself, and to use that. But the other thing is there still is a sealing statute. Even if there's a high burden, you can still file a motion asking that the old eviction case be sealed, even if especially if it was a long time ago. Michelle?
So I'm putting in the chat the website for rentervention.com. If you have an old eviction, and really anywhere, we're filing motions anywhere that were filed in the this century. The standard is so favorable that if you can try to do it now, if you go to this app, you just type in that your legal problem is sealing, it will get you to this app that I'm talking about. I can't really talk about computer things, but it is very simple. It just asks you a few questions like your case number, what happened. I will say, because the standard is so favorable, often we don't even have landlords' attorneys appearing because they know that it's going to be granted. It's been very rare that any of our motions have been denied. I really feel like there's a realization. I mean, if you go in and say, oh, I just didn't feel like paying my rent, that's not going to help. But I've seen some really dramatic stories. I talked with a young man at a sealing clinic who saw his mentor murdered in front of him, and of course led to depression, and he lost his job, and he put that in the motion. I think if you have some explanation, even if you got behind in rent, judges are in a place to hear that right now. And it's, these judges are used to seeing people without attorneys. So definitely you can do it. The e-filing is a little bit of a pain, but you can get through that. And, again, so many people I've talked to say, I have the money to move my kids to a better neighborhood, but I can't get in because of the eviction. So, definitely work on this. And if you have any interest in doing legislative work, if you have a good story, let us know. We are going to have this bill reintroduced in January.
All right, thank you. So during the presentation, you showed and shared some data about eviction filings, both pre-pandemic, during the pandemic, and now since the moratorium's been lifted. And there was a significant decrease of eviction filings. However, as you mentioned, Danica, evictions were still happening. And could you talk a little bit more about why those evictions were happening, during the time that the moratorium was in place?
There was a carve out. There was a carve out in the moratorium that said that you could still file an eviction case if someone was a threat to the health and safety of the people, was a threat to the health and safety, or that there were conditions that were a threat to health and safety. And so what we actually saw a lot of was landlords using that as a pretext to file evictions, or creating something like, oh, you forgot to take out a trash, that's a health and safety violation. Or if someone applied for rental assistance and either didn't get it or it was taking too long, they will use something as a pretext to say, oh, this person threatened me when I went to collect the rent. And that was a way to file an eviction. So we saw a lot of cases that did not hold up, that were not true whatsoever, just to try to get past the exception to the moratorium. In one case I had, the person was subsidized housing resident and failed to recertify. That means that she just didn't submit her paperwork. And they said that was a threat to the health and safety because maybe she didn't live there. And things like that were getting filed in court routinely.
Thanks, Danica. Sort of building off a little bit about that, could you, either of you, talk about, if you have an opinion, about what percentage of tenants have what you are able to determine is a meritorious defense?
We actually have some research about that. And so I don't want to come off with numbers that, and I'm not going to go look on the internet while I'm doing it. But all of the research that has looked at right to counsel, or even increasing the availability of legal services, there's a big study from Boston, and, have found that there are a lot of defenses that tenants can't articulate it on their own, because eviction trials would, go on for a minute and a half often, and tenants were shot down from trying to present cases on their own. A lot of defenses haven't gotten out there. I mean, our combined offices have a pretty good result in getting either cases dismissed, motions for summary judgment, or, and even when we don't, win a motion for summary judgment and win the case, having an attorney improves the settlement. And the attorneys in the ERP work with the rental assistance program to try to get people rental assistance. And that's really a win-win, where an eviction is really a lose-lose. So there are a lot of good reasons to be in there, even if the tenant acknowledges owing rent.
And I would say in a lot for Legal Aid Chicago, we have a 98% success rate in evictions. And even so, we can not meet the demand in any way of the people that come through the doors that may have a defense or that have a defense. We just can't meet the need. And so we just see people with a lot of defenses. There just are not a lot of resources available to help them. So I can't put a number on it, but a good number of the tenants that we see actually have some level of a defense, whether it's technical or substantive.
So you talked a little bit about, we've talked a lot about benefits to tenants in terms of the early resolution program and just, representation in eviction court generally, but could you talk a little bit more, Michelle, about what benefits are there to landlords for participating in the early resolution program?
Well, it's a good point. And I don't think that we made this point early on, that the early resolution program also provides legal assistance to what would be unrepresented landlords. So, and there, especially during the pandemic, there were a lot of filing requirements. Even now, landlords need advice getting through the system. And so some of the programs are funded to advise landlords. And I think that was a great strategic choice, not only because I think, unrepresented people generally need help in court, but also because it does benefit landlords and tenants. Now, granted, there are more tenant advocates just because more landlords already, have access to an attorney. But the other thing that I would say is the ability to access rental assistance. Just imagine losing $1 billion from the housing community in Illinois if government hadn't funded that rental assistance. And I don't understand at all the jurisdictions that did not get the rental assistance out, because it's economic development for the landlords. The landlord, they get that rental assistance check, they're going to their bank or to their mortgage or to Home Depot, and that money gets circulated. So over the last 2 years, I've been in different sort of programming with some of the landlords, advocates. A lot of the landlords lobbyists will talk about how important, and in fact, the COVID emergency bill, that part of what it did was have these rules on emergency rental assistance, was an agreed bill and had bipartisan support. So, there definitely are benefits to landlords in not losing tenants.
Thanks. So talking more about the housing assistance that came through, is there a way to check to see if a landlord did in fact receive that assistance? So
I wish it was a little bit easier. tenant, if it has gone through one of the government portals, and there are a lot of different ways that it was processed, the tenant has access to information about like when a check was mailed, or I can say that we're working very closely with the court-based, and so, you know, we're able to get information, not quite so much if it's like from the IDA portal, you know, again, Illinois Housing Development Authority, but that, you know, that portal does have some information. You know, I will say, again, it's kind of the macro versus the micro. I mean, could IDA have done a better job? You know, I mean, maybe, but IDA didn't do tenant facing or individual landlord facing programs when they were first get granted the first chunk of money for them to distribute. And they had to start from scratch with and distribute $300 million was the first appropriation for rental assistance. And they had to do it as quickly as possible because people were, you know, needed the rental assistance. The landlords and the tenants needed it to know that they were secure. And there needed to be regulations, and there needed to be software written in. So, you know, I mean, we know, even when it's been frustrating to wait, and I know I'm getting a little off the question here, but just to finish this thought, even when it's been frustrating to wait, we know that Illinois has done one of the best jobs among the states. And we know that because other states who couldn't get their money out had to give it back to Treasury, and Treasury could reallocate it. And the state of Illinois, Cook County, and the city of Chicago all got reallocated funds because they could get their money out.
Thank you. So it was mentioned earlier that Right to Counsel starts on July 1. How long, if you didn't already, how long is it going to last? And what can we kind of expect moving forward?
Well, it will last forever because the council will pass an ordinance, but this grant lasts for 3 years.
3 years.
Right, 3 years. Okay. Pivoting back to the early resolution program, Danica, could you share an example of a client that we've worked with that has gone through that program and what that looked like for that client?
So we get clients preferably right after their first court date, and not just right before the continuance, but we get a lot of ERP clients. I actually had an ERP client in the suburbs. And remember, with COVID, there were lots of social services that were just really shut down, that were inaccessible to people, and that were not available to provide supports that folks needed. And so I did have one ERP client who was being evicted under the threat of health and safety exception because her apartment was junky. And her apartment was junky because she had back surgery and couldn't keep it tidy, and did not have any social services to actually help her. So with this case, it was merely a matter of actually explaining to the landlord, because they weren't listening, explaining, like, I understand that you want her to clean this, but these are the things that have gotten in her way. Connecting her to social services through our social worker that we have in-house, so we can actually get her unit tidied and then get the eviction case dismissed. It was that easy, just to say, look, we have identified a company that will help come remove some of the things out of her apartment that she can't lift because she can't lift more than 10 pounds. And that was it. It was just that simple, of being that intermediary to connect a tenant to a resource that they couldn't access because they didn't know how. And so many of our ERP cases come in that way, whether it be connecting to rental assistance because of the digital divide. When you have a senior who could not access rental assistance because she's a senior citizen, her vision is going, she doesn't have a smartphone. Her son had the smartphone and he doesn't live with her, so she has to wait till he comes in. So getting one of our paralegals to sit down and help this person do an application for rental assistance, and getting that rental assistance, just getting the application filed, was enough to resolve the eviction case. So we are literally using our resources, both legal and social work, to stand in the gap for people that are vulnerable, that just can't do it themselves. They just need a little help.
Thanks, Danica. It was mentioned earlier that there's a pretty high bar to getting evictions sealed. So just a couple of more questions on this and we're going to wrap up. But could you talk about what that high bar is and what the standard is that the courts are looking at in order to make the determination about whether an eviction record should be sealed or not?
So when we get to August, beyond the cases that were filed under the lower standard and what we were dealing with, pre-pandemic, the standard is that the case is not well-based in law and fact. And attorneys it's gonna sound familiar because it sounds like the kind of standard for which the landlord or which the attorney would be sanctioned. That you, not just that, well, I've weighed the evidence and I'm going with the tenant, but the evidence is such that the law did not support or the facts did not support the landlord even filing the case. So, and that's, there are actually a couple pieces to it, and that's been approved by an Illinois appellate court case that that you have to meet this high standard. And again, we were able to accomplish sealing cases before that, often as part of a settlement. And again, a lot of judges would enter it if it was an agreed order, but some judges wouldn't, and some landlords wouldn't agree. That they didn't want to agree that they had met a standard that could mean that their client might be sanctioned. So, I of course I don't know where this will end up, but right now, we know that 40% of cases in the city of Chicago do not result in a judgment against the tenant. I've been to a bunch of these sealing clinics. So I talk to tenants who will say, I didn't even know that my landlord had filed an eviction until I got a credit report or a tenant screening report. And, I never went to eviction court. I moved out, the sheriff never came. And then they find out that the landlord did file an eviction, but while the case was pending, the tenant moved. So the landlord says, oh, I have possession. I'm not going to go back to court. I don't care. And so then the case just kind of hangs out there in limbo. And either sometimes they get dismissed or sometimes they should be dismissed for want of prosecution. But otherwise they're just hanging out there. And that's 40% of the cases. Either the tenant wins, the case is dismissed, there's a dismissal by agreement, or it's in this limbo state. And all of those cases should be sealed under this law. I mean, we've been working with the chief judge to enter a general administrative order, which we hope that he will do soon, that could deal with some of this like limbo problem. So even if, I will say, even if I could not get this bill passed again, with the presumptive sealing, with the super favorable standard, the very high standard has to be addressed. There's got to be, something in the middle.
Thank you, Michelle. I'm going to wrap this up with a final question. Danica, we all know that rents are going up, but could you talk about what's, kind of a common dollar amount that you see that tenants are being evicted for being, behind in their rents?
I can't give you a common dollar amount. At Legal Aid Chicago, we do primarily subsidized housing. We do some private housing where survivors of domestic violence are now in eviction court because their abusers stopped paying rent after, they've fled. But we've seen people evicted for as little, or an eviction file for as little as $8, $36. And that's just maddening to me, absolutely maddening. And then sometimes it's not even if a tenant owes rent, it's not that they actually owe rent, it's because their rent amount is incorrect in subsidized housing. But 1 month's rent is pretty typical, and no one should be evicted for just a single month's rent.
Thank you for ending on that very powerful note. And I want to thank both of you for a very, very informative and educational presentation. Thank you to everyone for joining us. This concludes our webinar series, and we really appreciate you taking the time to learn from these two experts today. Take care, everyone. Bye.